Today's topic of discussion is the tort of nuisance. Introduction to the tort of nuisance. Nuisance is an English word, which has been derived from French term, nutre, which means to do hurt or to annoy. Latin term, nuisere, which means to cause harm. Meaning of nuisance. Nuisance as a tort means unlawful interference with a person's use of enjoyment of land. Example, playing loud music in the middle of the night, running a factory which produces a lot of fumes. Kinds of nuisance. There are two types of nuisance. First is public nuisance, in which public at large get affected. It does not come under torts, but under crime. Second is private nuisance, in which a private individual gets affected. It is a civil wrong, therefore, it comes under the law of torts. But if by a particular act a person get to suffer greater harm, specially in case of a public nuisance, but because one person gets specially affected, then it will be counted as the tort of nuisance because the plaintiff has suffered special harm. Case, Ramraj Singh vs. Babalal. In this case, the plaintiff was running a clinic and the defendant had a brick grinding machine. Because the grinding of the brick the plaintiff's patients had to suffer. Although it was a public nuisance, but the plaintiff had suffered special harm, the court held that it will be considered as a tort, and the plaintiff will get compensations from the defendant. Essentials of private nuisance. A. Unreasonable interference. B. Interference with the engagement of land. Interference may be either, first is injury to the property itself, or second is injury to the comfort or health of the occupants of the certain property. C. Damages. Defenses of nuisance. First is prescription, easementary rights. Second is statutory authority.
I'm an icon, man. And my girl about a 10. I should fuck her in the Benz.